Hello everybody, welcome to iExamB's Legal B. This is Amrita, your law faculty at iExamB. Legal B has come up with a new series exclusively at this channel. Daily you will be getting some content in the form of important questions, topic wise from each subject. At 11 a.m. stay tuned every day. For that, don't forget to subscribe to Legal B, press the bell icon and stay updated with all the kind of beneficial updates, content and whatnot that you keep on getting at Legal B constantly. अगर आपकी कोई भी क्वेरीज है आप हमें सीधे इस नंबर पे कॉल कर सकते हैं या फिर आप इस वीडियो के कमेंट सेक्शन में भी लिख सकते हैं. यू कैन ऑल्सो विजिट आवर वेबसाइट www.iexambi.com for more details relating to courses, legal courses, and also if you want any queries if you are having in your mind, you can also email us at hello@iexambi.com. This is very good initiative that has been started by Legal B. एंड आज का इस पहले वीडियो में मैं आप लोगों के साथ डिस्कस करने वाली हूँ वेरी इंपॉर्टेंट टॉपिक फ्रॉम कोड ऑफ सिविल प्रोसीजर. द फर्स्ट टॉपिक that is preliminary and suits in general. This is the first part of CPC and very important concepts are covered in this topic. If you have any queries from this topic, you can also mention that in the comment section of this video. We'll be discussing some important questions from this part. This is a kind of legal mock test that you are getting in each video. So this is very helpful for your exam preparation and it will help you हैव एन आइडिया. आप इस वीडियो को सुनते वक्त पॉज करके अपना आंसर गेस कर सकते हैं and then you can check the correct answer. This will also help you check your knowledge. So it is kind of solving of mock test, a short mock test in each video daily at 11 a.m. So this is a very good initiative by Legal B. Stay updated and if you have any queries or you request or you want any questions or material on any of the topic, you can directly write to us in the comment section of this video. We will surely try to redress whatever your doubts are. Okay, so one more thing is that all the mock tests are free at www.iexambi.com. So do visit our website and check out the courses and the mock tests available. So let us start with the very first question. When did the Code of Civil Procedure come into force? Very important whenever you are going through such kind of legislations, whether it is constitution, CPC or IPC, always try to go through the commencement date, enforcement date, year of these acts, because questions are picked from these areas, at least for the important laws. So this is easy. But what happens is they give you the month and the date also, so sometimes it becomes confusing. And come into force is the time when the act has actually come into force or has been enforced. So the answer is C, 1st January 1909. This is provided under section 1 itself of CPC. Whenever I will tell you one thing where you can find these dates. Enactment date आपको मिल जाएगा एक्ट के टॉप राइट कॉर्नर में जो डेट मेंशन्ड होता है, कर्ली ब्रैकेट्स में होता है जनरली, that is what is the enactment date, and the commencement or the enforcement date is mentioned in the act itself. In the contents you will find it, like in CPC section 1 you can find it. It shall come into force on the 1st day of January 1909. So you should know the difference between both these kind of dates. Second, which of the following is not true about a decree? Now, decree, I would suggest the most important topic or the most important definitions of CPC, you have to do it very well. Whether it is decree, order, judgment, the clauses in which they are covered under section 2, and the difference between all these three concepts should be very clear in your mind. First, it conclusively determines rights of parties. B, it is a formal expression of an adjudication. It may be preliminary and final, but not partly preliminary and partly final. It is defined in section 2, clause 2 of CPC. Rejection of plaint is a type of decree. Now, what they have asked us is what is not true about a decree. Not true पूछा गया है. Always beware of such type of questions as well. Answer is C. It may be preliminary and final, but not partly preliminary and partly final. This is not true. A decree can be partly preliminary and partly final as well. This is directly mentioned in the section. Section 2 clause 2 decree means formal expression of an adjudication. What are the essential features? All those you should go through well. and it is going to be including rejection of plaint also. That is also true. If they would have given it the other way around, then the answer would have been different. And the decree can be partly preliminary as well as partly final. What it does not include, that also you should remember. You never know if a question comes from this. If an adjudication is there from which an appeal lies, then that appeal from an order is not included under decree. Any order of dismissal in default is also not included under the definition of decree. That is a simple order. Explanation clause, if you will check, you will be very clear with that. Preliminary can be partly preliminary and partly final also. Generally हम लोगों को preliminary final पता होता है, लेकिन partly preliminary partly final हम लोग miss कर जाते हैं. As per section 9 of CPC, courts should try all the suits of a civil nature. Very important section from Civil Procedure Code, that is the jurisdiction. Civil court jurisdiction is a very important topic from CPC, and the question has been framed relating to that only. Direct question. Accepting suits of which cognizance is either expressly or impliedly barred. Accepting suits of which cognizance is expressly barred. Accepting suits of which cognizance is impliedly barred. Including suits of which cognizance is impliedly barred. Including suits of which cognizance is expressly barred. So court should try all the suits of a civil nature. The jurisdiction is very broad. Interpretation is very broad. Remember that under section 9 of CPC. And the answer is A. Accepting suits of which cognizance is either expressly or impliedly barred. All the suits will be triable by civil court under section 9 of CPC. And the jurisdiction is quite wide of a civil court. Remember that. A suit to which right to property or an office is contested is a suit of civil nature, even if it is dependent upon a religious rite or a ceremony. It is a suit of civil nature only when it is not dependent upon a religious rite or a ceremony. It is a suit of civil nature only when it is dependent upon a religious rite or a ceremony. It is a suit of civil nature irrespective of whether it is dependent or not on a religious rite or ceremony in another suit. It is not a suit of civil nature if it is dependent upon a religious rite or a ceremony in another suit. What they have done, they have twisted it and changed the words of all these options and tried to make it confusing. It is not actually very confusing if your concept is very clear. Section 9 only covers this part as well. Answer is A. A suit to which right to property or an office is contested is a suit of civil nature, even if it is dependent upon a religious rite or a ceremony, irrespective of that. Explanations, if you will check, always try to check the explanations also. Illustrations, explanations, यहाँ से कई बार questions पूछे जाते हैं. CPC पे तो नहीं, but IPC में से illustration based questions काफ़ी आते हैं. Contracts में से आ जाते हैं. CPC में आप explanation से expect कर सकते हो. So explanation 1 covers this particular part directly. Res judicata is incorporated under which provision of CPC? Now this is a very important doctrine under CPC, and I would recommend that you should know the section numbers of these important doctrines always. Okay, so for having a very comprehensive preparation, you should be aware of the section. Res sub judice कौन से section में है, ये भी आप लोग मुझे comment section में बताइए इस video के. Res judicata is covered under section 11 of CPC. In order to apply the doctrine of res judicata, which of the following is a formal suit? Suit filed earlier and also decided earlier. In all the cases, suit filed earlier except an injunction suit. Suits decided earlier. In all the cases, suits decided earlier except an injunction suit. Now, पहले तो हमें ये समझना होगा कि हमें formal suit क्यों पता करना है. Whenever you are applying the doctrine of res judicata, obviously what you will see that the suit is already decided. When it is filed, will it matter or not? That is what is the main question behind this. Always whenever you are going through such kind of questions, try to break these questions. ये समझने की कोशिश कीजिए कि ये क्वेश्चन का मोटो क्या है एंड इन क्वेश्चंस के थ्रू हमें क्या पूछा जा रहा है और हमसे क्या एक्सपेक्ट किया जा रहा है. If you are able to understand that, then you can choose the most appropriate option in your answers. That is what is the trick of solving these MCQs, because all the options are quite near to each other. So when you are able to understand the intent of the examiner by breaking down that question, at that time you can very well solve the question with accuracy. इस डॉक्ट्रिन को अप्लाई करने के लिए फॉर्मर सूट पता होना जरूरी है. सो हाउ यू आर गोइंग टू डिसाइड दैट विच इज द फॉर्मर सूट? आंसर इज डी. whichever is decided earlier will be important for us in res judicata, obviously. क्योंकि सूट फाइल कभी भी हुआ हो, जो सूट पहले डिसाइड हुआ है that is going to be the one which we need to find out, because res judicata कब applicable होगा? When a prior case is decided. So obviously we will try to find out the case, the suit which is decided earlier, and this is also covered directly in section 11 explanation 1. Bar to further suit to a plaintiff is expressly provided under which section of CPC? Bar to further suit to a plaintiff now means further suit cannot be filed by a plaintiff. ऐसा बार एक्सप्रेसली कौन से सेक्शन में प्रोवाइड किया गया है? अब ये क्वेश्चन है तो बहुत सिंपल, जैसे मैंने आपसे कहा, ट्राई टू ब्रेक द क्वेश्चंस, try to understand whether you have covered this particular topic somewhere or is it the meaning of any particular doctrine. Try to understand that. And bar to further suit is covered under section 12, where a plaintiff is precluded by rules from instituting a further suit in respect of any particular cause of action. He shall not be entitled to institute a suit in respect of such cause of action in any court to which this code applies. So bar to further suit is direct provision under CPC section 12. Section 13 of CPC provides that a foreign judgment shall. फॉरेन जजमेंट सेक्शन 13 काफ़ी इंपॉर्टेंट सेक्शन है सीपीसी का. बहुत सारे एग्जाम्स में पूछा जाता है सेक्शन 13, सेक्शन 14. दैट्स व्हाई आई हैव टेकन क्वेश्चंस फ्रॉम बोथ इन दिस पर्टिकुलर वीडियो. आप ना इसके साथ साथ ये इंपॉर्टेंट प्रोविजंस को भी अपने बैराक में मार्क करते चलिए, सो दैट व्हेनेवर यू डिस्कस, व्हेनेवर यू स्टडी सीपीसी, at that time you are having important sections list also, that too topic wise. So ये सीरीज आपके लिए सीरियसली बहुत बेनिफिशियल होने वाली है. आप इन पीपीटीज को डाउनलोड करके प्रिंट्स भी ले सकते हैं. दैट विल ऑल्सो बी वेरी हेल्पफुल फॉर यू टू कीप अ रिकॉर्ड ऑफ ऑल द इम्पोर्टेंट क्वेश्चंस एंड इम्पोर्टेंट टॉपिक्स फॉर यू. Section 13, when foreign judgment is not conclusive, is covered and expressly under CPC, and according to that, option D will be the most appropriate, that it will be conclusive except in 6 conditions as provided. So there are 6 conditions. These are the 6 technical things. If they are not there, then this is going to fail. Unless and until these problems are not there, foreign judgment will always be considered as not conclusive. What are these 6 conditions? If suppose it has not been pronounced by a court of competent jurisdiction, या फिर वो decision merits पर नहीं दिया गया है, or else it has been obtained by fraud, or if on the face of the proceedings it is found that it is an incorrect view of international law, or the proceedings in which the judgment was obtained are against natural justice or opposed to natural justice. There is breach of any law that is in force in India. So these are the 7 grounds. If these are present, foreign judgment will not be conclusive. Remember that. Section 14 of CPC provides for a presumption. Now CPC also has presumption. Okay, remember that first. So that presumption is for what? That you have to remember. Jurisdiction of court passing foreign judgment, genuineness of copy of foreign judgment, genuineness of certified copy, jurisdiction of court passing foreign judgment and it has been passed on merits, jurisdiction of court passing foreign judgment if it is a certified copy of the judgment that is produced. Now this is not just sticking to the topic, that is whether it is a presumption relating to foreign judgment. ये तो सारे ही ऑप्शंस में है, बट काफ़ी स्पेसिफिक पूछा गया है आपको कि एक्चुअली प्रिजम्पशन किस चीज़ के बारे में, whether it is presumption in favor of the court having jurisdiction, whether it is presumption in favor of the document copy, whether it is a presumption in favor of the certified copy of foreign judgment. So this is a difficult or a tricky question if suppose you have not read the provision properly or thoroughly. सिर्फ आपने प्रिजम्पशन देख लिया, फॉरेन जजमेंट देख लिया, सेक्शन 14 देख लिया और आप चले गए एग्जाम देने, ऐसे क्वेश्चंस आप सॉल्व नहीं कर पाओगे. So that's why thorough knowledge is important, at least of the important provisions. Answer is E. It is presumption in favor of jurisdiction of the court that is passing the foreign judgment if certified copy of that judgment is produced. This is what is the correct option. Means certified copy अगर judgment की produce की जाती है, court will presume what? That the court was having, means which court? Indian court will presume that the foreign court was having a jurisdiction to pass that foreign judgment. So this is the crux of the provision, which should be very clear in your mind whenever you are going through such provisions. When a suit for compensation has to be filed by A for wrong done to his movable property by B in Calcutta, then A and B both are residing in Delhi. So where can the plaintiff A file a suit? Now this is relating to filing of suit. कहाँ पर suit file हो सकता है? If it is relating to compensation, wrong has been done by A to the movable property of B, which is located in Calcutta. A and B both are residing in Delhi. So where the plaintiff can file a suit, whether in Calcutta, Delhi, or only Calcutta because of cause of action is arising there, Delhi as it is the residence of B, Calcutta or Delhi at the option of A. अब ये options इसको काफ़ी confusing बना देते हैं. But again, if you know the provision, if you know the concept, then you can very easily solve the question. Calcutta or Delhi at the option of A. So remember what is the provision? Section 19 talks about it. Suits for compensation for wrongs to persons or movables. In this case, anywhere, either Calcutta where the cause of action is arisen or Delhi where they are residing, the parties are residing, suit can be filed anywhere. Or if at all we have to give an option, then the option has to be given to A. That is the defendant. Remember that. ये हमें ध्यान में नहीं रहता है. That the option will be given to whom? The defendant of that particular case against whom suit for compensation has to be filed. Sorry, not the defendant. Apologies for the mistake. Suit for compensation has to be filed by A in this particular case. So according to this particular provision, the plaintiff who is actually filing the suit for compensation in the local limits of jurisdiction of that court where he is residing, that will be the option of the plaintiff, whether he wants to choose Calcutta or Delhi. Apologies, it is not defendant because A is the plaintiff in this particular case or in this particular question. So as per section 19, choice will be at the option of A because A is the plaintiff. Suits other than for compensation for wrongs done to persons or immovable property shall be filed at. Now the similar question has been asked relating to immovable property. Any place where the defendant resides, place where the cause of action arises, any place where the defendant resides, carries out business or works for gain, place where the cause of action arises, or any place where the defendant is residing or carrying out business or is working for gain. Now this question I have not got the answer for you people. Any place where cause of action arose or both the parties are residing. Now इसका question का answer आप लोग मुझे देने वाले हैं and you can do that in the comment section of this video. Try to comment your answers in the comment section of this video. You can pause the video and check the entire question, or you can also check it from the PPT. Download the PPT and check it. And do answer the comments, answer in the comment section of this particular video. Then we'll be discussing on it in the next video on the same point. CPC, I will be continuing in that particular video with some more questions from some different topics of Code of Civil Procedure. Before I leave, I would announce that we are having a revision and practice test series of judiciary started already at iExamB. 6 months duration course is there. Then you will be getting practice tests in this course as well as one class you will be getting every week that will be discussing mains question answers with the expert faculty. So you can check the course out. And also there is an expert session arranged by iExamB with Robin Dutt sir, a senior counsel, practicing at Punjab and Haryana High Court and the Supreme Court of India. He is practicing for more than 25 years now and he's having a great experience in the litigation field. He can also guide the students on the point of judiciary exams, litigation, assistant district attorney, and all these examinations. So do join this workshop. This is a free workshop, you can register for it. इसके भी details आप लोग iExamB पर जाके check कर सकते हैं. For more details and for more such kind of beneficial content and updates, don't forget to subscribe to LegalB. And also prepare 50% faster with iExamB. Thank you everybody.